We have immigration updates every Tuesday at 5 p.m. Central Time, and we do answer live questions. Along with me is my business partner, Emily Neumann. Emily, what do we have today to discuss?
Today we want to talk about the issue of multiple H-1B registrations. We know we don't have that issue this year because they changed the lottery process, which is good. But we're still seeing the impacts of the prior years where people did have multiple registrations. So how is USCIS actually cracking down on that? What are we seeing right now? And then we'll talk about filing a PERM labor certification or an I-140 petition if you're not working for the company. Is that possible? Yes, it is. And so what to be aware of, what to look out for in that situation. Another common question we're getting with the layoff situation is for people who are on H-1B and have an approved I-140, and we're telling them you can change status to B2. Their question is always, but I have an approved I-140. Isn't that going to be a problem for B2 status? Because they know that that requires non-immigrant intent. So we'll talk about that. And lastly, just a reminder that the H4 EAD is a little peculiar in how it works with the auto extension, which is currently 540 days. You don't automatically qualify for the automatic extension. So we'll talk about what steps you have to take to make sure that you get the extension so that you can avoid any gaps in your employment authorization and the potential for losing your job.
Emily, I've had recently very many consultations going on. Every single day, a couple of people, and every week probably about 10 people, or 5 to 10 people are consulting me where they have filed multiple applications and now their H-1B is getting revoked, even though they have changed the company right now. So this happened in March of 2022. They applied in multiple applications, filed the H-1B and H1 in April, got the H-1B approval with a start date of October 1st, 2022. So it falls into the fiscal year of 2023. Now, why does the USCIS approve this H-1B? Because when in 2023, though, somewhere in May or July of 2023, we have seen USCIS published that approximately 160,000 people filed in the fiscal year of 2023. That is in 2022 October, though. Why did they approve the H-1B, track these people, and then now they are revoking these people after they moved on from a company A to company B?
Yeah, I mean, I think that with the registration process, we only have a 2-week window to submit all of the registrations. USCIS does not do any kind of pre-checking the registration. They're just looking at, is it a valid registration? Does it have all the signatures and everything? And so they just run the lottery based on that to get it done quickly. And then there's a 3-month filing window where they basically need to then try to get all of these approved by October 1st so that the employees can start on time. So they're not really able to vet all of these duplicates immediately during that process. They do approve them, and then while they're approved, they go back and do the digging. I mean, they really look into these petitions, into these companies. They check on who is the CEO of the company, who's the president of the company, who's the co-owner, who's the director, who's the registered agent, who's the incorporator, who's the attorney that filed these registrations. And when they see that they can easily cross-reference the same people with multiple companies, and then they get the lists of the companies and see that they registered the same people, it's so easy for them to figure it out, but it does take time. So obviously these were cases that were filed in 2022. 2 years later, they're still revoking these cases. So it does take time for them to do that initial digging and get all of their ducks in a row so that they can revoke with a finding of fraud against those companies.
Not to forget that they even check with which IP address these people have registered, which FedEx tracking number, FedEx account that they have used to mail these applications. They have, and if they have seen some of the notice of intent to revoke or notice of intent to deny H-1B applications where 7 companies have filed the same 100 people with all 7 different companies. So that shows a pattern that these people are committing fraud. So that's where these people have denied. Now, Emily, is there any way to fight these cases though? If I am working with company A, and the company A, without my knowledge, has contacted multiple, I mean, they have filed with multiple different companies. Is there any way to defend to not get the revocation of the H-1B? Because if I get the H-1B revoked, my subsequent all H-1Bs will be revoked. There is a chance I may get barred forever for collaborating fraudulently in obtaining the immigration benefits. So that's a permanent bar for me. Is there any way to defend these clients?
There can be, but it depends on the circumstances and where the case is at, where the person's status is at this point. So, for example, we've had situations where the employee has since moved on to another company that we represent. We filed the H-1B transfer, and USCIS sent a notice of intent to deny saying that, hey, this guy's first H-1B was revoked with the finding of fraud because the company submitted his registration with multiple different companies. We therefore intend to deny your H-1B because this person is not considered to be counted in the cap, because the revocation finding with fraud takes the person's cap number away. Well, the company that filed this new petition was not involved in that fraud at all. In our cases, the employee was not involved in it at all. They didn't even know about it. So we made those arguments in the notice of intent to deny, and we're able to get the transfer approved, even though the previous H-1B had been revoked. So that's kind of one way you can fight it. Another way, again, if the employee has already left the company, they're at the new company, they already got the transfer approved. Sometimes after USCIS revokes the first H-1B, they then go after the employee's transfer H-1B and send a notice of intent to revoke that. In that situation, same thing. We argue that this new company had no involvement in it. The beneficiary had no involvement in it. Neither of them had the opportunity to make any kind of arguments or explanation in the original notice of intent to revoke. And we've been successful in that way. If the H-1B is ultimately revoked or denied, the transfer or an extension in the future with another company, litigation may also help with that. Again, to get the original case reopened and still revoked, but perhaps without the finding of fraud. And that saves the cap number, because ultimately it's the companies that have access to the registration system, not the beneficiaries. But it's only the beneficiaries that are punished by this system. I mean, the company can just close down and open another company under a different name the next day. They're not facing any problems, but the beneficiary is about to lose their job, about to lose their status in the country. So those are some of the arguments we've been able to make in these situations to save the person's H-1B.
But if people are involved in multiple filings, so what we are noticing is that they're getting a lifetime ban, especially whenever they go out to the consulate. The reason is that because if the employee has collaborated with the employer in obtaining immigration benefits fraudulently, that's a lifetime ban. That means that they can never, ever come back into the United States. A lot of people have approached me and they said, look, I've filed with 5 companies, but all these 5 companies are unrelated companies. I've heard a lot of people telling on the YouTube saying that I can file with different companies, unrelated companies. And that is very wrong information. You got it. Very bad information. The main context here is if you really have a job with all these 5 companies. Let's say, for example, you're working for company A. Let's say your client is Coca-Cola company. Let's assume that company A files a H-1B, assuming that you're going to be working at Coca-Cola. That seems to be a genuine application. Now you approached 4 different companies. They don't have a job, and they're all anticipating that you're going to transfer the Coca-Cola contract to them. That even though company B, company C, company D, and company E are not related to company A, it is considered to be fraud. That's where people are mistakenly believe that, hey, they are not related. How is it fraud? That is not right. They may still consider it as a fraud. The other people, then they argue with me, Emily, saying that no, company B, C, D, E, F, G have the job. How do they have the job? Look, I have a job offer letter from them. Well, is the job offer letter enough? Do they really have a job? It's a consulting company. We know that they don't have an end client waiting for you until October 1st. In March or April, they don't have a waiting for you until October 1st. That is, if they don't have a job, they are filing the H-1B, even though they give you an offer letter. It is still will be considered to be fraud on the employer and fraud on the employee to cooperate with them. These companies have e-verified company. No, that's not enough that they're just e-verified company. Especially the Administrative Appeals Unit has clearly said that the multiple companies don't have to be related. The question mainly here is if there is a genuine job opportunity for you there. And job offer, I can create an email right now and shoot it to 5 billion people in the world, 10 billion people in the world, saying you all have job offer, everybody has $10,000 per month job offer. Does it mean it's a genuine job offer to all these 10 billion people? No. There must be a real genuine job offer for the employer to file in the H-1B lottery. And that's where a lot of the misconception happened. Before 2022, you can watch the videos we have posted in February of 2022, not to file the H-1Bs in multiple applications. In fact, the title of that in February of 2022 was, can I file H-1B with 10 companies at the same time? And we clearly said in that video, no, no, no. And that's where we are seeing the problems. But if you have any issues, so it's better you consult a lawyer so that you may take some precautionary methods so that you may get some relief, though, especially for those people who are going to outside the country for getting stamping. It's very tough to represent you at that point of time. But when you're here, there is a chance that you can get proper representation. Anything else, Emily, before we go to the next topic?
No. So I'm not working for company A, and they're going to file a PERM labor certification for me because my current company is not filing PERM, or they've put a pause on PERM for 6 months because of layoffs. Can I do that?
Absolutely, you can. Let's say, for example, you were working for ABC consulting company. Now you move to Microsoft, and Microsoft has put a bar, so they're not going to file the labor certification. Can you approach the ABC, your previous company? Can they file a PERM for you and I-140? Absolutely, they can. Do you need to be working for that company at the time of filing the labor certification? No. Do you need to be working with that company at the time when they file the I-140 application? No. Do you need to be working with that company at the time of the I-140 approval? No. Do you need to be working with the company at the time of filing a 485 application? No. All these are no. Now, why does some of the companies require you to work? That's their demand. They can demand that thing. There's nothing wrong in them demanding that you have to be working for the company, but it's not legally required for you to work for that company to file a PERM and I-140.
Yeah, one thing to be aware of if you are filing with a company that you're not actually working for is the requirement of establishing ability to pay. So whenever a company is going to be filing the I-140 petition, they have to include documentation that they have the ability to pay the salary that's being offered according to the labor certification from the priority date of this labor certification going forward. So that means the company has to provide their tax returns. And then typically, if you're working for the company, we would provide your W-2s and your pay statements to show, hey, they're already being paid. Obviously, if you're already being paid, they have the ability to pay because they're paying you. But for a company that you're not working for, they can't look at your W-2s and pay statements to see that the company has the ability to pay. Instead, they have to look at the company's tax returns or financial statements, or if it's a large employer, they may be able to provide a letter from their chief financial officer. So if you want to be cautious, if the company is doing this for 50 different people, they need to show that they have the ability to pay all 50 of those salaries. And that's coming from their net income or their net assets that are listed on their tax return. You don't want to get all the way through the labor certification and file your I-140 just to end up getting a denial because the company can't establish ability to pay because they filed for so many other people that are also not working for the company.
Okay, let's go to the next topic, Emily. Recently, we've seen a lot of layoffs, and Emily, USCIS has put a notice in their website, hey, why don't you guys move on to B2? And while you're on B2, if you get a job offer, you can switch back to H1B without going outside the country. But what about the people, though, who have an I-140 approved? B2 is not a dual intent visa. People with intent of immigrating into the United States may not be able to get the B2 or B1 visa. Now, if the person on H1B has an I-140 approval, can they still file a B2 if they have an I-140 approval, Emily?
Yes, and we've not seen any difficulties with that. Now, they do have to disclose in the application that an I-140 approval is there. It does ask that question, have you ever had an immigrant petition filed on your behalf? So you have to answer that yes. But I have yet to see a B2 application get an RFE or a denial simply because someone has an approved I-140, especially when it's in the layoff situation. Now, does that mean you could go to the consulate and apply for the B2 visa when you have this approved I-140? No, consulate is looking at that much differently, and they are applying the intent issue. You have to prove your non-immigrant intent, and having an approved I-140 is the exact opposite of that. But for USCIS, they are offering this as a lifeline to people who are in a layoff situation. And we've filed tons of change of status to B2, filed the change of status back to H1B, not had any issues, even though the person had an approved I-140.
Questions with regards to the H4 EAD. Now, we see a lot of mistakes. If you follow our directions in the next 5 to 8 minutes, guys, you can avoid the gaps in the H4 EAD. As you know, people work on H1B, they will have a continuous employment. They file a H1B extension. Even if the H1B expires, if the extension is pending, you can work for a period of 240 days. So we don't see a lot of gaps in the employment unless now the Trump comes again. Now if the denial starts again, that's a different reason. But at least right now, we don't see any of these gaps though. But we see the people who are on H4 EAD because of their mismanagement though. We see there is a gap of employment, and that's where the problem comes. Because if you're doing a job at a particular place and you leave the job, you may not get that job because they will replace you with somebody else. So to avoid that, there are a couple of things that you need to do. If you have the H4 EAD, when you're filing for the H4 EAD extension, always file along with your spouse H1B. So H1B, H4, and EAD together, if you file, you will get the H4 plus EAD approved along with the H1B. And if by any chance it's taking a longer time, you can convert the H1B into premium processing, only H1B, not H4, not EAD. You only pay one and you get three. That doesn't happen with immigration. You only pay one premium processing, you get the H1B, H4, and EAD free. Buy one, get two free. And this is real, guys. This is real. Now, USCIS does approve H4 plus EAD. By any chance, 0.0%, they don't approve the H4 and EAD. If you're filed together, you contact our office, we'll take care of that easily for you. Now, so file it along with the H1B. You will get the approval along with the H1B. That is the number one thing that you need to do. Now we have some companies, some law firms, I don't want to name them, they are our competitors though, and they don't want to file the EAD together. They only want to file the H1B and they want to file the H4 but not the EAD. Oopsie, oopsie, oop. What do we do in that situation, Emily?
So if they are filing the H1B and the H4, but not the EAD. Number one, have them file early. You can file up to 6 months before the H-1B expires. Still recommend to file it in premium processing because the H-4 and the H-1B will be approved together in premium processing. When you get that H-4 approved, it extends your H-4 status for the next 3 years, just like it does for your spouse's H-1B status. Now, if you file the I-765 application, as long as you file it before your current EAD expires, which is why you need to file the H-1B and H-4 early, getting that 765 receipt notice plus your already approved H-4 extension gives you the automatic extension of your EAD for 540 days. But it only works if your H-4 has already been extended. Now, what if the company is not filing the H-4 and they're only going to file the H-1B?
Oh, crazy.
What can you do then? So how do you get your H-4 I-94 extended if the company is not filing?
Okay, there is a scenario for that too. For these bad companies and bad law firms, there is a scenario for that where you can still avoid the gap. If the H-1B gets extended, and if you can even if the H-1B is pending, when the H-1B is pending, you can file the H-4 plus EAD based on the receipt notice of the H-1B. And once the H-1B is approved, and if your H-4 is still valid, so let's say, for example, your husband is filing an H-1B extension, his H-1B is valid, H-1B and H-4 and EAD is valid until September 30th. Now, your husband's H-1B application is filed by the company. They are not filing your H-4 plus EAD. So what you do is that you can go to an outside lawyer and file the H-4 plus EAD while the H-1B is pending. And if that H-1B is approved, there is an option where you can go to Mexico. We call this as a Margarita Magic. You go to Mexico. When you come back, now, when you go to Mexico, your I-94 with the current H-4 should be valid though. Since I gave the example of that H-1 and H-4 EAD is expiring in September 30th of 2024, and you got the spouse's H-1B approval, you can go to Mexico and come back before September 30th of 2024. Use your spouse's H-1B approval to show, look, my husband has the H-1B approval until September 30th of 2027. Please, then they will grant you the H-4 I-94 until September 30th, 2027. In that case, you have an I-94 extended. You have the EAD, even though EAD is not extended, you have 540-day rule that came out recently, which was 180 days before, which was 540 days before. Now it's again 540 days. Now you can be employed for up to 540 days and EAD is not taking that much time. In that way, you can avoid the employment gaps. Now, if you follow this 5 minutes thing though, you will avoid the gaps in the employment. Any other things, Emily, I missed out on that?
What tips do you have for someone who's doing the Margarita Magic in Mexico? Can they just, drive across the border and stop there and tell the officer, hey, extend my I-94?
There are some cases that have been successful in Laredo, especially. In Laredo, they're very tired of these people right now. If you travel through car and you come back though, there is 50% of the time they may not do anything. They will just allow you to come into the United States though. But if you fly to Mexico and you fly back to Mexico, then you have approximately 98% success rate instead of 50% success rate of driving to the border and come back. Let me ask you another question, Emily. Now, in the same scenario, where my H-4 and EAD and my spouse's H-1B is expiring in September 30th of 2024, and my wife's H-1B got approved. Now I'm traveling to Mexico, but I don't have my visa stamping until September 30th of 2024. Can I go to Mexico and come back?
Yes, so that's where the automatic...
I don't have the visa, Emily.
Yeah, Automatic visa revalidation gives you a valid visa, a make-believe automatic visa that allows you to come back as long as your H4 I-94 has not yet expired. So you can go to Mexico for less than 30 days. So go there, go to Cancun, stay the night, have a margarita. And when you come back, you use your expired H4 visa stamp plus your currently valid H4 I-94 plus your spouse's extended H-1B approval notice. And you can come back in, and most of the time they will give you an extended I-94 for your H4. Now you do need to look into the rules of traveling to Mexico. When you have an expired visa stamp, you may have to get a tourist visa to Mexico in advance, but that's relatively easy to get, so should be doable. But yes, so even if your H4 stamping is expired, that's where automatic visa revalidation comes in, which is another special rule that allows you to travel only to Canada or Mexico, only for less than 30 days and not apply for a new visa stamp. Come back in as long as you have an unexpired I-94.
Shall we go to the questions, Emily?
Yep.
I have an interesting topic, which Saj Vora from YouTube is asking the question. My PERM is under process and I'm maxing out an H1B. What are my options? I will tell a couple of options, Emily, and if I miss anything, if you have a H4 option, H4 EAD option, definitely that is the best. If not, if you have the H4 option, that is one of the other things that you can consider. You can consider moving to F1 visa. And once the I-140 is approved, you can come back to H1B once using the I-140. If you can move to B2, and once the I-140 is approved, you can come back to H1B. That's an option available. You can go to your home country, and once the I-140 is approved, you can get the H1B filed in the consular processing using the I-140 approval and come back. Now, for all these things, the crucial thing is that even if you are not working for that company, the company has to proceed on the labor and I-140. If they don't want to proceed, though, you are definitely out of luck. And there are other creative solutions where if your PERM labor is just 1 month or 2 months short, there are some creative solutions where you don't have to stop employment. You may want to consult an immigration lawyer where you can spend some time in Mexico, or you can spend some time in India, at your home country, where you can extend, because any time period you spend outside the country will not be considered to be within the 6-year period. So if you take a vacation and spend 1 month in India and you come back, you can extend the H-1B by that 1 month. Does it has to be a vacation? Can you actually go to India and work for 2 months and then come back if your H-1B validity is there? The answer is yes. Even though you're drawing a paycheck when you're working outside the country, we do not consider that time period as a time period you spend on the H-1B in the United States. So there are many steps that you can follow for you to extend the H-1B. But main key thing is that your company must be cooperative.
And don't wait till the last minute to figure out those options.
Right. If your H-1B is expiring in September 30th, 2024, don't contact our office in the month of September 2024. Contact us right now. Or if it's expiring in September 2025, this is the right time to contact. It's very hard to find the solutions when you're right at the edge and about to fall down.
All right. Nitin says, my wife is working on H-1B with a petition approved till 2026. She also has an EAD from my EB1 and wants to know if she moves to the EAD, will her H-1B still be valid if she has to use it later? So it kind of depends on what you mean by valid. I'm assuming this is a cap subject H-1B. She's been counted in the cap. That means that if she has not used up her 6 years, she can come back to H-1B at any point in time and get those remaining years of the 6-year limit without going through the lottery again. But if she's on the EAD, she has to have the H-1B filed for consular processing, exit, get the visa stamp, and come back. She'll need to have a valid advance parole for that to avoid losing or abandoning the 485 that's pending. So yes, she can always come back to H-1B later if she's not hit the 6-year limit. If she has hit the 6-year limit and she has her own approved I-140, she can do the same thing. Come back to H-1B at any time in the future, not go through the lottery again, as long as her I-140's priority date is not current. Now, if she has the valid H-1B and hasn't expired yet, and she uses the EAD, and now she wants to come back to work for the same employer under the same terms and conditions, her H-1B has not expired yet, and the company hasn't withdrawn it, it's still considered to be valid. It's called a dormant H-1B at that point, and she can revive it by just traveling and coming back in on H-1B. Now she's back in H-1B status.
AJ Punch from Twitter has this question. If the PERM is filed by 2 different companies, is that going to create a problem? Absolutely not. It doesn't create any problem. Absolutely doesn't create any problem.
AK says, I got my EB-1A approved and I'm applying for AOS tomorrow, but my wife and son will be traveling to India in mid-June. Will this affect the status of their pending AOS and EAD? It depends on what their status is now. For example, if they are on O3 and you're on O1 and they don't have the advanced parole yet, yeah, that's going to be a problem. They will abandon the 485 if they travel without advanced parole. If they have H4 or L2 and they travel, no problem at all. You do not abandon a pending 485 even if you leave without advanced parole, but that's only for H or L, nobody else. If they're in any other status, they will abandon the 485 if they do not wait for the advanced parole to be approved.
Emily, I was being told that they're going to deny the advanced parole. Will that cause any problem for my 485 if I travel while the advanced parole is pending?
Yeah, assuming you're H or L and you travel while the advanced parole is pending, because I just said it's not going to abandon the 485, you're totally fine. Yes, they're going to deny your I-131 application, but that has 0 impact on your I-485 application. So you just come back on your H or L visa stamp, you'll continue in adjustment of status, and that green card will continue to be processed. No impact at all, even though your 131 has been denied.
Vivek Saraswat has this question. Does the Margarita Magic also work for Canada? Yes, it works as for Canada too. Although we doubt that sometimes when you travel by car and spend a night and come back, they may or may not issue a new I-94. But yes, the Margarita Magic is for both Mexico and Canada. Why do we use Canada and Mexico? Because the automatic revalidation is only applicable when you don't have a visa to only Canada and Mexico. It's not applicable if you go outside the country to India. So that's the reason we always say Mexico. And the reason why we give it to Mexico is also that it's easier to get the visa to Mexico in cases where people require a visa. In some of the cases, they don't even require a visa to go to Mexico. But yeah, Canada is, the Margarita Magic works in Canada too. Can you go to Mexico or Canada for the first time H-1B visa stamping after change of status from to H-1B for F1? The answer is yes, you can.
Enchanto says, I'm currently in the U.S. on L1 with my employer A and also got an H-1B consular processing approval with employer B while I was home in India. Do I need to go through the H-1B cap with my current employer? Yeah, so you're not considered counted yet. So just because you got that consular or processing approval with employer B, you're still subject to the cap unless that was a change of status approval that actually took effect, or you got the visa stamp with employer B. So if you're intending to work for employer B now, you can go for stamping and come in on H-1B and go to work for employer B. But employer A cannot file an H-1B for you without going through the lottery.
Jayanti Kumar has this question. Her I-94 has been shortened because of the passport expiration date. Now her passport has been renewed. What are the options she has to extend her visa without stepping outside the country? She knows that she can just go outside the country and come back, and then I-94 will be extended. But what are the options? Yeah, you can file the extension of status here in United States. Absolutely not a problem. You can file it here. Now, a lot of people ask me this question. Let's say, for example, your I-94 is only expiring on September 30th of 2024, and your visa and or I-797, let's say, is expiring in April of 2025. Can you only apply the extension until April of 2025 on H1B? No, you can apply for a 3-year period of extension too. Not a problem at all. When you get a chance of extension, don't extend it from September to April. Do it for 3 years.
Peter says that in the visa bulletin for June, it's mentioned that there's EB2 and EB3 retrogression is likely. This is for the rest of the world. He says there's no transparency on how these dates are set. Can we file a FOIA, Freedom of Information Act request for the data? We actually have one pending. I can't remember how many months ago it was filed. Seems like 6 months to a year. But we asked exactly that for the inventory data, because back in the olden days, USCIS actually put out the 485 inventory every so often. That stopped around Trump coming into office, and it has not come back since then. We haven't received the data yet, but we have asked for it.
Abby Joshi has this question. My spouse is a Canadian citizen. Can she travel here on a visa waiver and convert into H4, or does she needs to go for the H4 visa though? The Canadian citizens do not need a visa. There's a visa waiver program, but however, they should not come on visa waiver program if their intention is to settle here on H4. They should go with the H4 process, not the visa waiver program. Now, the lucky thing is that they don't need anything for the H4. All they need is your H1B approval. That's good enough to come into United States on a H4. So, but make sure they don't come on a visa waiver program. They request for the H4 entry into United States.
Ravi Teja says, does the primary H-1B holder need to have the visa stamp prior to the H-4 getting the visa stamp? My spouse is going to India and has the expired stamp. No, there's no requirement that you actually get the H-1B stamped in your passport in order for your H-4 spouse to get the stamp. You being in the U.S. with a valid H-1B with the I-94 working for the company is sufficient. Your wife just needs to carry your H-1B approval notice, marriage certificate, helpful to have employment verification letter from your company and your recent pay statements.
Emily, big question for you. I know what the big question for you. When the Trump comes into the office, of course, he will try to remove the H4 EAD. We know that. He tried to remove the DACA EADs too, where, of course, people fought that in the court and the court blocked it. Otherwise, he would have taken 1 million people employment authorization out. He tried it. What about H4 EAD? Can he remove it, or do we have any resources in the court? I mean, do we have any course? I mean, do you have any, can we go to court and fight this issue?
So the H4 EAD is a little bit more stable compared to DACA because it was created through regulation, which means the only way you can end it is through regulation. Now, the Trump administration did start the regulatory process to end the H4 EAD. They never went very far with it. They didn't even issue the proposed regulation. So it didn't go anywhere. This time around, will they do that again? I think it's probably pretty likely. They may be further along and better able to get that moving faster. So ultimately, the only way to, if they do propose the regulation, go through the notice and comment, issue the final regulation, then yes, a lawsuit could potentially be filed on the basis that maybe they didn't follow the regulatory process correctly to eliminate the H4 EAD. Or maybe they are don't go through the regulatory process at all and just say it's going to be our policy not to issue these anymore. Well, that definitely opens them up to litigation because they have to go through the regulatory process. So there are certainly options, and we'll just have to see if the Trump administration would make that a high priority or maybe set it off to the side like they did before.
Yeah, but it's a nightmare for me to think about Trump.
Yeah.
Oh my goodness. I don't want to go into that 2016 to 2020 Emily. Can a green card be filed, labor and I-140 be filed when you are in H4? This question comes very common. Yes, it can be filed. This question is coming from Aditya Jamula. Yes, it can be filed on H4 EAD. We have seen a lot of people moving from H1 to H4 when they max out on it. And then once they get the I-140 approved, they swing back to H1B. That's very common, Aditya.
Faraz says, I transferred my SEVIS but did not cancel my OPT because I was not aware of doing it. Now my DSO emailed me that I would not be able to apply for OPT again on the master's level. So I'm assuming you applied for the OPT, actually got the OPT card and then didn't use it and decided instead to go back to school and got the new I-20. Unfortunately, I think your DSO is right. Even though you're not using that OPT because USCIS actually issued you the card, you can't get OPT again unless you go up a degree level.
Tata Ateria Pavan Kumar has this question. When can I approach the employer to initiate filing of the I-140, considering I'm planning to transit OPT to H-1B and hoping to get selected in the H-1B lottery in 2025. Now, here's the thing though. If you do not have any plans of traveling outside the country, what I would recommend to you is probably file an I-140 right now, because getting an earlier priority date is absolutely very, very important for you. Meet Singh has this question, but it's a little bit more complicated than what he's thinking. He's saying that his wife did not get the H-1B. Can she go to Canada? And she's trying to come back on L1 after 1 year working because she probably exhausted her H-1B lottery system and she wants to come back on the L1. Now, the question is that while she's in Canada, what's the best visa for her to travel into the United States? B2 or H4? Because I'm assuming Meet Singh is on H1B, the best approach is definitely H4, not B2. Because B2 is a single intent visa, the rejection percentage is higher. H4 rejection percentage very, very, very low. And H4 is very appropriate because she's coming, you're already here. And the fact that you are here, B2 has a chance of rejection very high because the husband is in the United States. However, one thing that you need to understand, any time period that she is going to spend here in the United States, either on B2 or H4, will be deducted from the 1 year period. You already know me that if somebody wants to come on L1 visa, they must work outside the country for the company for 1 year. So any time period that they spend in United States, either H4 or B2, will be deducted from the time period that they're working in Canada. So make sure. So it's not like they're doing a job there and they're spending most of the time here. Then they have to spend 1 full year physically in Canada.
Geraldine says, is it true that if you're on H-1B and have an approved I-140, which is not yet current, you can continue renewing your H-1B without limit until your I-140 becomes current? Yes, that's exactly right. Once you have that approved I-140, whenever your date is not current, you can keep using that approved I-140 to extend your H-1B in 3-year increments until the date becomes current. This is assuming that the I-140 has been approved for at least 180 days and not withdrawn by the company that filed it. You can use that I-140 to get extensions with any employer. Even if you move from company A to company B and company B does not start a PERM labor certification, you can still move to company C, company D, company E. As long as your date is not current, you can keep extending your H-1B.
Emily, I will be not be coming on the next 2 Tuesdays. I think so. You're going to go with Stephen, I guess. But the question is for Stephen, automatic EAD extensions are not recognized by the driving license people here. Is there any litigation chance for it?
Well, I'm assuming it's a C9 EAD, because if it's an H4 EAD, you'd have the I-94. So you'd use your I-94,
right.
not your EAD.
C9, yeah.
It's a C9 EAD. You should be able to use your 485 receipt instead of the EAD. But I know it depends on the state. But your 485 receipt is also on the list of acceptable documents for many states on renewing.
Yeah, but still, yeah, there are some states that doesn't recognize the 485 receipt notice, especially Texas does not.
Sumit from Facebook says, my H4 EAD was approved 70 days ago, but I still haven't received the card. Please guide me on the next steps. The employer is asking for the physical card, saying the approval notice is not sufficient and is planning to terminate the job. So the employer is correct. Having the approval notice is not an acceptable document for I-9 re-verification purposes. You need to have the physical card. First thing I'd say is immediately refile it, pay the filing fee again, just get it filed, get the receipt number. If your current EAD hasn't expired yet, I'm assuming you already have your H4 extended. So by refiling it, you're getting a new receipt notice that you can use for your automatic extension of the 540 days, because you already have your H4 extended. You have a new receipt notice for a 765 that was filed before your EAD card expired. If your old EAD card already expired, still refile it immediately and then contact the Ombudsman office for help to see if they can help you expedite it, or call USCIS to do an expedite request. My experience is they don't consider that to be a USCIS error. If they give the card to the post office and the post office makes it disappear, that's your fault, not their fault. So a lot of times they won't consider that an expedite, but the Ombudsman may be able to help.
Harini asked this question that when you change the job, how early we have to file the I-485J supplement? Is it before you join, as soon as you join, within certain time after you join? The answer is none of them are true. You don't have to file an I-485J supplement if you are moving from company A to company B after 485 has been filed for more than 180 days. We normally recommend people only if you have an RFE, that is request for further information, then you can respond to them with the I-485J. If there is a 485 interview though, if you're not working for the company that filed for the I-140 and 485, you have to take the I-485J supplement with the new company. But it's not mandatory that you have to file it before, at the time of moving to the company, or within a certain period of time. It's only when the RFE or there is an interview.
Kumar says, I lost my I-797 approval for my H1 extension, and my current H1 expires in September 2024. What are my options if my duplicate application takes beyond September? Well, these days, the only thing you need the original for is the driver's license. If you're traveling, they'll accept a copy of the I-797 approval. Your employer probably had the original at some point, and so they were able to do the I-9 re-verification. So it's probably not going to be an issue, except unless you have not gotten your driver's license approved yet.
Okay. Question that on what Emily has said is that if I-140 can be used for multiple times, Emily, what if my I-140 is approved and I see no hope in getting the green card? I want to go to India and I want to stay there for 10 years, and can I come back on H1B using the old I-140 approval with the company, Emily, which was not
Yeah,
withdrawn?
absolutely. As long as the I-140 was approved for at least 180 days, and if the company withdrew it, it had to be approved for at least 180 days, or they did not withdraw it, and that priority date on that I-140 is not current, you can have any employer, it doesn't even have to be the same employer, new employer can file an H-1B requesting consular processing. You are not subject to the cap because you've already been counted. You're not subject to the 6-year limit because you have an approved I-140. Get a 3-year H-1B, get the visa stamp, and come back.
The villain from the X has this question. I have a master's degree in USA. If I move to India, when I'm going to file the H-1B, can I be considered in the master's quota? Absolutely, yes. It doesn't require that you have to be in USA to be counted toward the master's quota. What is required is you must have a master's degree from a non-profit accredited university from USA. That's it. You can be you can be India, you can be in Canada, you can be in Mexico. They can still consider to be. They can still consider. They will still consider to in the master's quota. As this question, go ahead, Emily.
Matthew says, what are the academic documents required for filing a new H-1B petition for consular processing? So you need the degree certificate and the transcripts or mark sheets for whatever degree qualifies you for the position. And if it's a foreign degree, we would typically get an education evaluation to show that it's equivalent to a US degree.
As this question, he or she wants to work, is working for one company. Can this person work for the second company parallelly at the same time on H-1B? It's called concurrently working for two companies. The answer is yes, you can. If the second company is going to file a concurrently filed H-1B, you can. Also has a question. I don't want to tell my first company that I'm working for second company. Absolutely, you can do so. All you need to do is that the second company need to know that you'll be working for the first company and the second company. The first company need not know that you're working for the second company. Jay has this question that if I have an I-140 approval, will it be risky in extending my visa status? It depends. Now, that if it is an H-1B, H4, L1, or L2, you will have no problem, none whatsoever at all, in extending the visa statuses though. If it's other than L's and H-1Bs though, or H4s, you may have a problem in extending. You may have to consult a lawyer. If you're not on H visas or L visas, you should consult a lawyer whether you should go with the I-140 or not. But if H's, H1s, H4s, L1s, and L2s will have no problem extending the visa status here in the United States and also getting the stamping done in the consulate.
Botic says, can you switch companies when the I-140 is in the filed stage? So I'm assuming the I-140 is already pending. I'm assuming this is an I-140 that has been filed by the company, like an EB2 or EB3 based on a PERM. Can you? Yes, probably. Should you? That depends on a number of factors. Number one, is this your very first I-140? If it is, your priority date isn't locked in yet. And so if you leave that company and they withdraw your I-140 before it gets approved, you have to start over and you lose that priority date. So it's not a very good idea to switch at that point. Now, if you locked in your priority date with company A 6 years ago, and this is now company C, and they are in the process, well, then, yeah, you can switch. You don't need this I-140 for anything because you're using company A's I-140 from 6 years ago. No problem. So it really just depends on a couple of factors there.
Ramjan Ali has this question. He's working for company A as a primary employer. He's working for company B as a concurrent employer. He lost the job with the primary employer. Can he just continue working with the concurrent employer? It's a gray area at this point of time. We recommend the concurrently filed H-1B file an amendment of the H-1B instead of just continuing working with the concurrently filed H-1B. That's what we recommend. But having said that, it's a gray area. The directions is not clear. We just want to be safer. Ranyan has this question. Is it taking longer time for PERM application for UK citizens? No, UK citizens don't have a special line in the PERM. In the PERM, they don't. Now, when it comes to the green card, though, the UK citizens born in UK definitely have a faster line than Indian nationals. But when it comes to the PERM application, they don't look into which country you're born. Right now, the processing time is approximately between 12 months to about 13 months for the PERM labor application to be adjudicated.
Vinay says, currently on L1 and had my H-1B picked up in the lottery. Is it possible for my employer to apply for the H-1B and H4 EAD for my spouse together without the approved I-140? No, you're not eligible for H4 EAD unless your spouse has an approved I-140 or is approved beyond the 6-year limit of H-1B based on a pending labor certification.
Adding to concurrent H-1B, are there implications for the green card processing? Will there be any problem when you go for visa stamping in India? Let me tell you about visa stamping. That's a problem there. A little bit technical problem. Let's say you're working for company A as a primary employer. Let's call that company as Coca-Cola. And let's say you're working with ABC Consulting Company on the side as a concurrent employer. The problem here is when you go to stamping, though, you can get on. One problem is when you get the stamping and when you try to come back into United States, though, the CBP, the Customs Border Protection Unit at the port of entry, there is no way they can give I-94 for two companies. So you will end up working for only Coca-Cola. So then every time you travel outside the country and you come back in, the ABC company has to file one more concurrently filed H-1B. Otherwise, you cannot continue working for two companies at the same time. Now, coming to the green card process. Will it create a problem for the green card process? Oops, you're working for two companies? No, absolutely not. They love you. You're working for two companies. You're paying a lot of taxes for the United States. Nothing wrong. I have done an H-1B for a person. 6 companies he's working for. 6 companies. This guy's a dentist. In fact, my wife, until recently, was getting 8 W-2s. She's working for 8 different companies at the same time. This is very common in the healthcare field. They do work for multiple companies in healthcare field, though. But yeah, in IT profession, that's not very common. But since the time of COVID, we have seen a lot of people working for multiple employers. Never seen any problem at all. Never seen any problem. As long as the things are done properly, legally, absolutely not a problem working for multiple companies. Can you work for 3 companies? Absolutely. I said I did H-1Bs for 6 companies. The guy's working is a dentist, different locations. Some of them only 2 to 3 hours. Yes, it is allowed.
Olajumoke says, I have an EB3 visa ongoing, but due to the retrogression, I'm not seeing any changes. Can I apply for an H-1B visa? I am a USRN. So I'm assuming you mean registered nurse. Nurses can have a tough time with the H-1B because not every nurse position requires a bachelor's degree in nursing. You can get an RN, you can become a licensed nurse with an associate's degree in many states. So it's all going to boil down to what position you are being offered. Does that particular position, is it one that normally requires a bachelor's degree in nursing instead of an associate's? If that's the case, then the company may be able to sponsor you, but you have to go through the lottery unless they are a CAP exempt organization. So it can be a little tough. It might not be an option.
Got the PERM receipt notice, and the email says it takes 11 to 12 months for the labor approval. Is there any process speeding up and approval? Don't trust them. It's actually 12 to 13 months. It's not 11 to 12 months right now. That is the current date that we are looking into right now. What are the chances of the H1B second lottery? Very, very less this time, though. The reason is that if you look into the amount of people who applied for the duplicate H1B applications, went down by almost 90%. So there are very less chances for a duplicate, for a second H1B lottery. Anything else, Emily?
Yeah, going back to that PERM approval taking 11 to 12 months, and what's the process for speeding it up? There isn't one. There's no premium processing, so you can't pay an extra fee to speed it up. There's no expedites. DOL does not care. They claim they do first in, first out, no matter what. There's no situation where they will expedite a labor certification. Now, we do have lawsuits pending regarding this unreasonable delay in PERM processing, and those are still ongoing. So hopefully we will see some improvement based on these lawsuits, but that's really the only choice at this point, is to file a lawsuit. And it's kind of a new area, so we don't have any success stories yet.
Anything else,
I think
Emily?
we're out of time.
Yeah.
So thanks everyone for joining us. Don't forget that we do have a free daily conference call where you can join in and get your questions answered there. And you can always set up a consultation with us or any of our attorneys here at Reddy Neumann Brown by going to rnlawgroup.com. Click the button for consultation, and you can find all of our schedules and book it online easily.
Thank you guys for